Since it was your assignment, sit down there. No, you're wrong.
Just so everybody knows, we've got about 2 or 3 minutes before the meeting starts, but I'm gonna just hit this thing to turn it on, so just so you know, it could pick up what we're saying.
I'd like to welcome everyone to our special board meeting this evening. I'm going to do roll call. Please state here when I call your name. Jeff? Here. Tony? Here. Melinda? Here. Mike?
Here.
Tiffany?
Here.
Rain?
Here.
And myself. Attorney Macy is here to address the board with issues regarding records requests, possible violations of board policy, campaigning, and legal bills for legal update. And we will be only answering board questions at this time. So Attorney Macy, when you're ready.
Well, good evening and thank you. I thought it was time to update on a number of things. There have been quite a few questions, some misinformation, and some other legal concerns existing within the process here. And as there's gonna be several different elections coming up, I think it's good we sit down and talk to the board about that, and have a good understanding moving forward to preserve everybody's rights and responsibilities and understandings for the district, and move forward with those. So with that, again, I'd suggest that maybe time to do that. The timing is good because the referendum, the recall petition was filed today with the signatures, so that'll be reviewed and move forward. One of my colleagues will be working with your board clerk about that process. I'll say again, and I know I've said it before, we as a firm don't weigh in on any of the issues, pro or con, in different groups. We represent the district as a whole. I know sometimes when you're in the middle of those things and you give advice, it seems like you're supporting one group or another. We don't. The end of the story with that is to simply protect the district and make sure that the process is correct and legal. Let me first talk about records issues here within the district. When we were asked to come on as legal counsel for the district, we were asked to review different things, identify concerns, and then make recommendations into issues that were pending or that we saw from the different work that we do with different districts. And one of the early things that we had noticed was a concern over the public records requests in your meetings and how your meetings were structured, noticed, and put together. They're both pretty serious areas of the law that your citizens have a right to have open meetings, notice of meetings, appropriate agendas, appropriate things noticed for agendas, and also the right to ask for timely records requests and to have records preserved and taken care of. That's the same here as everywhere, but it is really important under the law throughout Wisconsin. And we saw concerns with that. One of the first meetings we had with the district, a couple of the board members, some of the administration, was about the process used for records requests. We thought it was inadequate. We made a number of suggestions in regards to that to make sure how they were being cataloged, how they were being responded to, whether they were timely, and again made a number of requests with that. Unfortunately, to date, we haven't seen that necessarily followed, the advice that we were given with that. I think it's time we revisit that. I'd re-emphasize to the board that they weigh in on that. Mr. Sari, to his credit, has already started a draft to update the district's policies and procedures about how we deal with records requests. And for example, just along the lines of some of that, when there are records that deal with the investigation, or there's notice that goes to people that might be involved in that, and they have a time period that they can respond, we would advise and write the letters for administration to send those out, what would be to send out, and how to do that legally. It wasn't done. So records delays occurred to your public because they weren't done correctly, didn't quite frankly follow the advice that was given in that regards. That's not Mr. Sari. Like I say, in working with him as he's come on, like I say, he's already started a process to correct some of this, to get a handle on who particularly is going to deal with responses, to properly number responses, to communicate back with people that are making requests, all the basic kind of things that are really important to make sure that it's done right here at the district. In terms of your notices, it was not appropriate to have one-word notices as to what an agenda item would be. We noticed that immediately, and that had to be corrected. It wasn't appropriate to simply list the statute site that was going to be listed to go into closed session. That's pretty much understood across the state, but it was something that was occurring here going back quite a while, and that's been corrected, and I think your public gets better notices. I know that you've gone online with some of this so more people can participate. I know there was a lot of pushback to that, but again, your board has been more open in regards to providing more information to the public about that, despite some criticism of that. More recently, there was a request for documents that when we looked for the documents, we found out they have been destroyed. And some administrative people have admitted that they were either directed or that certain drives were destroyed relating back to past administration and past parts of investigations. I gotta disclose that to the board because it's very concerning. It's got potential liability to the district, but probably somebody that was acting outside the scope of their employment will have to bring in other people in regards to that. During the past investigation, we were considering a forensics audit of some of your systems as what was happening with some of your records. The board saved the cost on that for now, but that might change. I know you have concerns with costs in your budget, legal fees, but in all due respect, some of the things that are going on historically have not been complete. We're gonna have to look at that. It's probably gonna involve law enforcement, and I can't sugarcoat that in all due respects. People have a right to know the records and a chance to review those, and we will get that straightened out. That's not taking any political position, that's the law of the state of Wisconsin, as far as that goes. Mr. Sorry, I don't know if you have anything further to add on what you're working on with the policy, but that's pretty much what I wanted to up to date the board on your agendas, your notices, and your documents.
Yeah, part of it is having to do with vague requests and trying to get more information to make the process be more expedient by asking the requesters to give us some key terms that we could type in to do it. Also on the data extraction and compilation, the sorting and the review process of records, and then sometimes because of confidential information that is in these records, the redacting that has to take place, and then talking about the costs that it could be incurred for some of those pieces to be completed prior to releasing the records. So we're putting that into a more formal process, and I have it on the agenda for next week to give to the board for your review.
I'm gonna comment a little bit further later on some other records-related pieces and legal fees. Let me come back to that later under the last item.
All right, yep.
I could proceed to the second item unless there's anything else.
You want any questions at this
I
time?
could on the first one.
Anybody have any questions regarding the records request?
So the records that were destroyed, these were documents, email or accounts. Can you speak to that? Is that what you're talking about, or physical documentation, or both?
No, they were drives, electronic drives that contain some of your documents, past administration records, internal documents, emails, other things like that. Best we can tell, we're gonna have to dig into that more.
Accounts?
I don't know about financial accounts, not that I'm aware of, but I
Or
don't know.
user accounts?
User account, probably.
So Jim, how long should records be stored before they can be destroyed?
There's different time periods depending on which records they are. General rule of thumb is about 7 years.
So are you saying,
General.
you're saying we're missing 7 years worth, or you're not quite sure yet?
We're not sure just how much, but at least in response to this current records request dealing with some of the past administration, those drives were deleted.
Okay,
And some of your staff has acknowledged they were deleted. How that happened, why that happened, who was involved in that, is gonna take more investigation.
okay. Anybody else have any questions? Okay, so then we can go on to the possible violations of a board policy, campaigning.
Sure. Let me mention that because, again, it's another area we've been working on, but we don't seem to be able to pick up enough ground on this to get it correct, quite frankly. In election scenarios, and quite frankly, with the past big election in November, there was quite a bit of discussion about this in school districts across the state that we worked on. Pretty much common sense not to have politics involved in things at school, on school grounds, pretty much understood. But there continues to be activity within this district over the recall and over your primary and other aspects of things. So there have been a number of communications as of January 11th to folks not to use the school logo in regards to politicking. Communications on the 13th of January not to use the school premises to solicit documents for signing or for politicking on school grounds, certainly not in your classroom, certainly not asking the staff to do that on school premises. Again, what people do on their own time, away from school, not with kids, not with the other, is understood and protected, but not during school and on school grounds. You have different policies about the use of your facilities, again, that keeps things related to education, like all districts do. Staff ethics, another policy, a variety of policies that touch on this. And again, it's kind of just understood in all due respects. But then there was another email as of January 21st, again, that one specifically to the staff, some communication to board not to be soliciting on school grounds, bringing in treats and donuts for staff to support an election during the school time. Most people understand is not appropriate, but that happens at your district. So we've asked people to please not do that. And when I say people, this isn't picking sides, this is no side ought to interfere with your educational environment and your property, even your athletic events at school. That's the basic request for a good month plus at this point. Point is, as of even within a couple days ago, we've still had to say, board members as well, staff as well, don't violate district policy. You're kind of at a crossroads now where you may have to discipline people, you may have to censure board members if you don't follow your own policies. Let me just say, in terms of regulating and representing the board as a whole, not interested in being in the middle of that, either is Mr. Sari as far as that goes. We're just here to try to get you through this and respect what the public wants in terms of an election and protect the district and have you stay within your policies. And I would really encourage that, again, from everybody's point of view. The other thing I would say is you can differ on different things, that's fine, but I've said this from the beginning of being here, it can be a lot more civil. And I would really encourage everybody in that regard to absolutely differ on your opinions on different policies and procedures. But the rest is a little tough. It's a little tough to kind of work through too, okay? For what it's worth. That is a problem. I want to make it very clear to everybody, you are going to have to get to a point where you may have to look at some further efforts as to what you're going to do about that.
Okay.
And I'd really encourage everybody, please just take it out of the schools. Let the teachers teach. We've got teachers coming to us saying, we're getting pressured to do this and to run around with petitions and to do that, either internally among staff or from board members. Please don't do that. It's not helping your educational community. It's certainly not helping your kids. For what it's worth, that's the same here as everywhere, as far as that goes. That's all I have to say about that, but I think it's a serious issue, folks, and I encourage that you follow your policies in that regard. Are there any questions?
So as a board, if we take a look at censuring board members for doing this, I guess what would be the process for that? I have the policy right here. As a board, do we have to look at this and determine if this is something we're going to do or have a conversation? I guess what do you advise?
Well, I think all business of a board is done at a board meeting. First, let me say that. It's another thing that we kind of noticed as we came on is, aside from the agenda items, aside from the proper notices, aside from making sure things weren't just citing a statute. We also have advised the board not to have walking quorums, not to have 3 people meet with a superintendent after your board meetings, when the board meetings are over, other things like that. You really got to leave your discussions of your board meetings here at the board meetings. That aside, back to your question, if a board was to consider the censure of other board members for violation of policy, that would take an agended item so the public knows that would occur. That would take a public, that's probably in public. I can't think of a reason that would be in closed session. And then have the discussion and a decision of the board and open to what you want to do. That would not be for tonight because that's not an agended item. For example, I know you're not asking for that for tonight, just the process, but that's what that would be.
I'm not sure if I can speak to our policy on this, but the form of censure by resolution passed would be by the majority of the board in an open session. The enforcement would be removal from board committee assignments for the remainder of the year until the following organizational meeting of the board at which the president is authorized to continue to withhold committee assignment. Approval of the sanction is adopted through bylaw 0155 committees. Restriction on board members' rights granted by policy, including requesting items for a board meeting agenda. Referral to proceed with efforts to remove the board member from office for cause, which means inefficiency, neglect of duty, official misconduct, or malfeasance. Referral to law enforcement if alleged misconduct is potentially unlawful, or other efforts to pursue compliance with adherence to the policy as determined by the board. So just making the board aware of the code of conduct and the enforcement policy with regards to that.
Right, and my understanding is that, as you read that, sounds a lot like the Neola policy that you've adopted.
Yes, it's one of our new renewal policies, yep.
Let me just mention, being familiar with that policy, some of it makes suggestions to the board, some of it is advice to the board in terms of code of conduct type things.
Okay.
Other things are different in terms of the actual violations of policy, and there are concerns and allegations. It would take a review and a decision that things actually occurred. With those members, certainly if there was any accusation against any board member, they certainly would have a right to weigh in, defend themselves, and explain. And it may not be right in terms of allegations as far as that goes. It's always the case. But a distinction under that particular policy is things that are suggested. Let me give you an example. A lot of off-duty conduct people may say is good or bad, and the public decides whether it's good or bad for an elected official. Other things that might be on premises or at board meetings or things are a little different. Okay, and that's what I'd suggest you would.
Okay. Thank you. Anybody have any other questions or comments? Okay, so the next thing is the legal bills, legal update.
Yeah, there's been a number of things referred to me. One of the things in public comment a few meetings ago, I was at some of the other stuff that I've seen. And I think just to update on what some of that is, there have been questions about the past investigation. Quite frankly, quite a bit of misinformation about some of that. So to the degree that I can at least, from my lens or the part that we were involved in, explain, in fairness to everybody here as to what some of that was. One of the things that I've seen quite a bit of misinformation about was there was a past letter from the president of the board to board member Werner a while back, either August or September last summer. And there's been questions as to whether or not legal fees were incurred for the board president to write that letter. First of all, we were just hired at the time. I didn't get much of a chance to weigh in and didn't weigh in all due respects. I think we had interviewed in earlier September of that summer. So We were not involved at all in the writing of that letter. The Below Vetter firm, the prior law firm, as of December 6th of 2024, had weighed in and put in writing they were not involved and no legal fees were expended upon the cost of drafting or putting that letter together between the two board members. So whatever miscommunication, I have been updated to say that a prior administrator of the firm wrote a letter to a record requester under his belief that there were fees incurred. I don't know where he got that information. He certainly didn't consult with me about that. I don't think he consulted with the Below Vetter firm, but that response was not correct in all due respects. Because both firms, the two firms you work with, have indicated no fees, we were not involved in that letter. That's one of the issues about legal fees. The other issue is there's a group of issues. One is whether or not our firm was engaged to be involved in the termination of your district administrator. Well, first of all, that never came up in any discussions prior to us interviewing, putting in a proposal. And quite frankly, I don't think it has ever come up with anybody we've represented, at least that I've been involved in probably 40 years of doing this job. That's not what we do. We're asked to come in and represent the school district, and we're kind of your general counsel on all different matters, some of which might be employment. So that is not true, and thought we would clear that up. I had been involved in, again, for background on this, to at least clear up some of the information from the process and the legal aspect of the investigation piece of things. When we were engaged, among other things, it became apparent that there were already pending performance concerns in the potential drafting of a program of improvement or performance improvement plan regarding your past administrator. This is just fact. There were other concerns that had also come to light again before we were even engaged with the firm. At some point I was also asked about what is the process for evaluating your superintendent. And it generally can involve comments from all of the board, a consensus evaluation, a report out. There are many ways you can do it. I had not heard much of a scenario where a president of the board would individually do the evaluation of the superintendent or district administrator, not share that with the rest of the board and implement that. There was some suggestion that might have been part of the past history, but I at least was not necessarily familiar with that type of process. It's usually more because the person's hired and reviewed by the whole board. It's usually not just a member of the board. But again, we're just asked to give input with that. Based on the number of different concerns we were asked about, what is a process for where we are with the overall aspect of the performance concerns, the possible program of improvement or PIP, performance plan, and maybe eventually a full evaluation. I had recommended a process to the board and met with the board about that in closed session in closed session about some of the pending issues that existed and if they had any others that were existing. Because the prior firm was already working on the performance issues and performance plan potential, it made sense cost-effective wise for them to do the investigation of the concerns. So the process was set up like this. The board was instructed, don't make any decision, final conclusions on what you may want to do about your district administrator. In fairness to the administrator, these are concerns, they're not findings. Let a firm investigate that. They will report back to you. Don't be part of the investigation. Don't disrupt the investigation. Just let it take its course in fairness to everybody. That may result in a finding of whether you think there's enough information to go to hearing or whether or not there is nothing or whether or not you may want further investigation. That process occurred. During the process of that investigation, and investigations always take too long, I acknowledge that, and it took a couple months, and that's always very frustrating. I can also tell you that your district administrator was told that this was occurring, was told what the process would be, was told that there would be no decisions made about this, and he also worked with having his own legal counsel during this process as far as that goes. The board eventually, through the information gained through the other firm, we did meet again in closed session on December 11th, and I reviewed what the board, what some of the findings were in regards to concerns at the time. The questions presented to the board to consider that night, again, is not what you want to do at the end of the day. It was, do you think there's enough information to warrant a hearing? Do you want more information and send it back to investigation? Or do you think this is enough to say there's not a concern here, let's finish this and be done with it, okay? That was the process. That's fair. That's typical in terms of the kind of processes. Just to be clear, I wasn't brought in to terminate anybody and didn't necessarily weigh in on that. It's presenting information for the board to determine the process. There were concerns, this is public record information. These are not findings, let me be very clear about that, but things that the board was looking at the time that came through was whether or not there were correct procedures that were handled regarding an extension of an employment contract that resulted in an increase in wages that may have not come to the Board of Education for approval. In other words, did something occur between the administrator and some past board people, extend a contract, give more money without board approval? That's a concern. That was one of the things that came with that. Another had to do with whether or not there were concerns with exceeding authority regarding the development of future athletic facilities within the district. Things that were looked at were whether or not there were conflicts of interest, whether there were plans being drawn up at the expense of the district or not at the expense of the district, whether outside people were spending monies and efforts to maybe get the business of the district and not being upfront with the full board as to what was going on between where you all wanted to go as a community over your athletic fields or not. I'm not saying there were findings, it's just was there enough concern with some of these things to warrant maybe getting to a hearing to flesh all of that out. There were issues within some of those things as to all of that was being transparent enough, with enough information to the board on a variety of things. For example, the administration policy issue may come to the board or a decision the board has to make. And the administration may give one or two options for the board when in fact there may be 6. Is that fair to the board if they don't get all of the options available to them, where the administration sort of controls what comes to the board and might steer? I'm only suggesting the allegation. Again, I want to be clear, not a finding. For example, just as an example, when law firms were asked to give a proposal to the board for services, the administrative sifted through those to determine which options would be presented to the board and not all of the options to the board, in a sense to kind of could arguably be controlling legal services. If you had options for major purchases, did the district get all of the different options and were all vendors considered? Did you even consider going out for bids for different things, whether it's required or not? Was the board informed of that? Or was the board only given small payments over a long period of time for fairly expensive purchases that wasn't fully transparent to your elected officials trying to make decisions in regards to that. I'm only saying there were concerns raised and issues raised within that, going back through the administration and then maybe even the prior administration in that regards. Were there concerns over how some of your funds were being used and whether expenditures were within the correct funds? Were there concerns over how legal advice was being obtained, whether the legal advice provided to the board was actually gained by lawyers, or whether or not that was sort of filtered in a way that it wasn't quite exactly what was suggested or correct? For example, if the opinion was that we received legal advice from the WASB, Wisconsin Association of School Boards, that says this particular board member has a conflict of interest, for those of us in the business, that's a red flag right away. When somebody says our law firm is the WSB, that's kind of a red flag right away to those of us that practice law. Let me first say that the WSB has very good attorneys. I'm friends with many of them, and I have a lot of respect for what they do. No question about that. But the WSB is an association. They can't give you legal advice. They can't give any client-specific legal advice. So if you're told the WSB gave us advice to this district on our specific issue, that's not possible. And the WSB cannot do that. And quite frankly, I respect them enough to say it, but they wouldn't do that, because then they jeopardize their own association and their own status. So to say we can get the advice for maybe $250, why pay a law firm? Because you gotta go to a law firm to get legal advice. You can't get advice for your specific issues as an association. So an issue was the information you're getting, was it correct? Was it really legal advice? Were other requests for documentation for some of this that wasn't found and wasn't available as to whether there really was the advice coming to the district? I'm not saying it occurred. I'm saying, was there enough information to warrant a hearing to sort through all of that to determine whether things were done appropriately or not? There were other issues the board had reviewed that evening that I was with him. There were clearly relationships between the administration, communications issue between the administration and some of the board. An issue was your administration too controlling so that it usurped the rights of the people you elect to actually be on your school board to make decisions? Those were issues that were being considered and reviewed in regards to that. Were some of your board members bullied, pressured, threatened to quit over who was really running your district? I don't have any comment or any advice on that. To me, that's up to the elected folks as to who you want your elected officials to be. But there can be a rub between the administration and the board as to whether it's too controlling or whether things are left to your elected officials to make the decisions on your behalf. I will tell you that when we're asked to come in, I said this in the beginning, I say this everywhere I go, I'll say this till I'm done doing this. We represent the district, we represent the board as a whole, what the majority of the board decides, but we have a lot of respect for the citizens who elect the board members to run the hearing. I got asked, why did we pay you to move tables? Well, I got to tell you, 5 minutes I did move some tables around when I came to a board meeting. I never saw a board meeting where your elected officials don't sit between the citizens that elect them and the decisions are made by your Board of Education. So I suggested it be set up like this. When I asked, why isn't your board set up like this? And why is it kind of open to a discussion by all kinds of people that aren't your elected officials, separate from public comment, which is important, because it won't be rearranged the way the board has asked that our board meetings be run, was the answer I got. I said, give me 5 minutes. It's a board meeting of the elected officials, and that's respect for the people that elect your board officials. It's as simple as that. There were concerns with how some of this as to how much was really the board or the board's power was usurped. the end of the day, after reviewing the information, I'm reviewing some of it, not all of it, but the board had the options again. Don't decide what you want to do at the end of the day. It's the three options. Is there enough concern that warrants a hearing? Do you want some more investigation? I gotta at least mention this piece on that last piece. There have been concerns that your email communication within the system is reviewed first, even though it might be to board members from some of you by some administration, and may be filtered in regards to what you're communicating to your elected officials. I don't know. It would take a forensics audit to go through to determine just what was going on with some of that stuff. Although some staff did report that did happen, that systems were put in place to monitor communications from you to your board to be filtered by your administration in the past, communicated through some of the rest of your staff, and whether I'm told that doesn't happen anymore, but it was a concern to be further reviewed. It would take a forensics audit, which would be pretty expensive. It was decided not to do that, at least to date. Based on the other records thing I talked about, that may have to change now. Again, going back to those options, the other was, is this not concerning, and ought we just end this at this point and be done with it? The board voted to say there's enough to proceed to a hearing on it. Again, I want to be really clear, that's not making any decision, it's just whether this ought to be sorted out in a hearing. Mr. Space had an opportunity to respond to all of the allegations. He was represented by counsel. I was simply informed, directed to inform his counsel that the board had decided to proceed to at least a hearing on it, at which point, within a couple of days, Mr. Space elected to retire. He had a full opportunity for a hearing. Nobody has said he did all of these things wrong, and that can't be determined in fairness till after a hearing, so that didn't occur. We then negotiated a retirement agreement. He did have a multiple-year contract that ended earlier. Some fees are paid through that. It's an economic decision the board made and discussed at that time. Over the costs of paying lawyers to have a hearing and further disruption within the district, or focus back to things the board determined, they thought it was best to work out the arrangement, and so did Mr. Space. That's nothing negative to Mr. Space. He's done good things with the district as well. There is no findings, there weren't findings, and there wasn't anything inappropriate with this process. All rights were accommodated in regards to that and more. Anything to the contrary, I take great exception to in all due respects. That's some of the issues in regards to the legal pieces of things. Let me just take that note here. We've already addressed the issue of the elections and the recall pieces. We don't give advice. The district has paid no money toward either group in regards to advice for their particular interests. There have been fees for the cost of elections. There will be further fees. That's the same here as everywhere. That's always involved when you have elections and recall issues, but that's not to favor one side or the other. That's to make sure the district's process is appropriate as far as that goes. Also been asked about emails and communications during the investigation. It's probably the last thing I'll mention here. First of all the bills, I think there's some current ones that are being reviewed now to see if there's legal advice that may have to be redacted, but quite frankly, our bills are routinely requested, and I know that, and I don't have any problem with that ever. Either does Below that, or another very good firm as far as that goes. So that's not an issue, and they're not gonna suggest that there's been any fees ever paid by this district for supporting one group or the other in regards to the elections. If there's an issue that I'm missing with that, let me know. I'd like to know that or see that, but not that I am aware of or would condone as far as that goes. That's the last one that I was gonna mention in that regard. Like I said, there was more aspects of the investigation, but from a board standpoint, this board did not make any decisions regarding Mr. Space. They entered into negotiations regarding a retirement. That's with dignity, that's in respect, that's in accommodation of business decision on behalf of this district, and like I say, in respect for the good things Mr. Space could have done. That's the report I can give. Like I say, there are a number of pending things of concern within the district to bring to the board's attention.
Okay. Anybody have any questions?
I do. Can you
can't
tell
take-
me why this meeting was
We
requested?
can't take questions from the public, I apologize.
Okay,
It's only for the board members.
okay,
But I would ask if you have questions to send me an email and we'll address those.
I will.
Okay. Any questions from the board members?
So, was Andy told about the process before the December 11th meeting that we had in closed session, which he informed when we first met?
My recollection is that you're gonna meet on a Monday, and I believe I called him on that Friday. He was concerned that there was gonna be a closed session and he wasn't gonna be involved in it. That occurs from time to time, but I know I personally talked to him about performance concerns and what the process would be, that there certainly was no decision. He would be informed of that as it went through, as it went along. Yes.
Ron, can you rightfully tell us, the agreement we had between Andy, in our meeting, it said that he was not allowed to talk negatively about the board, or vice versa, the board was not to talk negatively about Andy. And that was kind of the agreement we signed. Can you entail us a little bit about what went down with that and how that was done? Is that something you can speak on a little bit, just to clarify for the public of what should be said or what can be said, or what can be disclosed from Mr. Space, what can be disclosed from the board? And I myself would like to know what we are allowed as board members to disclose to the public, other than what's been done through open records here best, because, I've been pretty quiet, I don't say too much about it, I got a respect for Andy, but I've got a lot of questions from a lot of people and I can't answer them, because
Sure.
I don't know how far I can go with that,
Sure.
so if you can clarify that.
When you reach an agreement on a separation situation, it's usually best for everybody that people move on, right? And not have continuing debates or continuing fights about that. So it's not uncommon necessarily that you have what's called a non-disparagement clause. And that specifically says Mr. Space will not talk negatively about the district or the board or board members, okay? And if he does, that's a violation of the agreement. It also says the board will not speak negatively of him, but it also specifically says the board has every right to talk about the reasons it was considering a hearing, which is what I talked about tonight. That's clearly in the agreement. And it also says the district clearly can respond to public records requests, so documents and other aspects. For example, the document I was reading from, the document I passed out to the board the night we met and the board voted to go to hearing, that's a public document. Mr. Space has received that document, although not timely. He initially received that so that he could respond to that knowing it would be a public document.
Now, if there's a breach of that non-disparagement, agreement, I guess what's the replication of not following that contract if we feel that that contract wasn't withheld, going both ways?
We have to review what that breach was, how serious that breach was. Sometimes it's a letter to say this has come to our attention. It might be a rumor, and in fairness to Mr. Space, it may be, I didn't say that, here's what I said. Okay. If it's more serious, that it goes after one of the board members specifically in a very negative light, that's beyond some of this other aspect, that could be a breach in regards to that.
Thank you for that.
So, I have one question. Andy did an email on defending some of these allegations to the board, and you addressed that email. Can you just clarify or address what he was trying to tell us? Because the items that he indicated were not true with what you gave us as a response. And it now is in the public hands, and I would like that clarified for the public.
Yeah, what I'd suggest is you certainly can make public my letter in response to him. Totally appropriate to make. I don't have that with me tonight,
Okay.
but it's totally appropriate to share with the public. We definitely responded to correct some of the things that were in that letter. No
Okay.
question about that.
Okay,
Some of which we addressed tonight as I did this overview of things, like the process and some of the other aspects.
okay. Anybody else have any questions?
Just to verify, there were concerns about email filters or email rules that allowed people other than the recipient and the sender, allowed access to those emails.
There was a concern about that. There's still a concern about that in all due respects.
Do we know, or do the concerns extend to individuals who have access to other people's email, could stop the email possibly? So the recipient would never receive it?
I don't, not that I know of, but I don't know that for sure. And again, we stopped short in the investigation. There were the other concerns, not the expense of the full forensic, that some of the rest of you may know more about than me in terms of that area. It's beyond my area of expertise. And again, I wasn't investigating, the other firm was, but even they had said at this point we would need to do a forensics audit to figure out that. What we did find was some of this wasn't processed, that emails were being filtered to other people, although not necessarily right to the recipient first, that there was continued access to prior employees, no longer employees of the district for a while, that had access to information of the district that probably should not have for a period of time. There are also contractual arrangements with some of that that may not have come to the board through the past as well. There were issues.
So what would have been the cost if we would have, I would estimate of, if we would have continued the investigation, if we would have done, if we would have kept going before Andy, decided to retire?
Fair enough. It would have taken more preparation before hearing, working with witnesses, working with documents and other aspects. So there probably would have been days of attorney's time to prep for that. There would have probably been a couple of days of hearing. The board would have incurred the cost of paying an attorney to finalize the investigation, prepare witnesses and put in the case before the board. Separate counsel would have sat with the board to help the board through the process, run probably, like I say, a couple of days of hearing. You're easily in the thousands and thousands of dollars. I mean, and again, it's hard to say how long that would have gone, but, and then that's separate from potential appeals and other disputes after that. When they say reasonable attorney's fees, it's expensive. And that's why it was a business decision on behalf of the board, and from my recommendations, based on the fact that you had an extended contract for a couple of years, you didn't pay even the full amount of the second semester, much less all of next year, separate from the legal fees involved. Again, from what I do and working on these, it was a pretty good business decision from my point of view, if you ask me that. Estimating an exact dollar amount, you can see it would have been pretty expensive.
So would you say it would be around or more than what, the separation agreement?
It certainly had that potential, and certainly the cost of the contract alone would have, if we would have got to that point that you paid out the full contract. No, easily, you're not even close to it, paying out that full contract would have been.
questions? So I just wanna say a couple things. First of all, thank you for coming in, Attorney Macy. I think this, meeting was beneficial, with the amount of requests and questions that, Ron has been receiving. Attorney Macy felt it was imperative to come. And then also, our board has listened to significant concerns and questions from you. And I think it was good to actually bring legal counsel in to clarify those questions to become more transparent. Now, could we have done things differently to be more transparent in the beginning? Probably, but you have to understand that this board has never done or anything like this, including myself. It's a difficult process for anybody to go through, not only for Mr. Space, but for our community and for our board members as well. I mean, we had relationships with him. It's difficult for the teachers and the staff, and so what I'm asking is that you come together as a community to support each other, and that you support this board, and that we will support you. With all due respect with regard to the recall, I would tell you that you each have your own choice on how you want to vote for that. I would highly ask you to review the information tonight and try to determine whether or not that is valid. Without getting into that, I would say I'm gonna continue to serve and do the best I can as an individual with this board. I will try my best to better serve you and this board, and to try to bring this community together. And just know that this is a very difficult situation, not just for myself and my family, but also very difficult for every board member up here as well, with their family and friends. So I'm just asking for the community support for all of us, whatever side you're on, and that we do what's right for kids going forward. Ron, do you have anything you'd like to say, or are we good?
I'm not picking sides, I'm staying neutral.
Okay. Okay, so with that said, I think the last part is the adjournment, unless anybody else has questions, but, do I have a motion to adjourn the meeting? And do I have a second? Thank you. Well, meeting has been adjourned. Thank you for attending.